Dear students, this is the second lecture of Private International Law. In the previous lecture, we started with a question which reflects the importance of the existence of a branch of law which is named the Private International Law. So the question was, why is private international law necessary? We started with some examples that doesn't make or doesn't lead to problematics regarding the applicable law. Then after that, sorry, we move to another three examples in which there are some difficulties and problems in choosing the applicable law and deciding the competent court simply because they consist of a foreign element. Then after that, we made like a comparison between the private international law and public international law, and we have also said what is the reason that a private international law is given that name, and we illustrated how is the naming of the international law, the private international law, as an international one is not kind of paradox. Then after that, we reached the definition of private international law. I think that I told you before that there is no specific definition for private international law. And this is simply because the jurists of private international law, they vary in their perspectives in the number of the elements that the definition includes. So some of these jurists say that there are uh, three just subject matters of private international law. So the definition will only include these three subject matters. However, other jurists of international law think that there are more than three subject matters of international law. So the definition of private international law from their perspective will reflect the six subject matters of private international law. So it depends on the jurist and his point of view regarding private international law and what are the matters that private international law covers. And now we'll start with the definition that I believe that it is the most accurate definition among the definitions that I like reviewed during the uh, during or while making this private international material. Well, the definition of private international law, as mentioned here, varies according to the subject matters, as we mentioned, that jurists consider them as part of it. So the number of these subject matters will lead to the different to different like definitions of private international law, because jurists of international law vary uh, regarding this matter. Okay, in fact, some jurists consider that nationality and domicile, for example, which are like the most important topics of private international law, in my opinion, they consider that domicile and nationality, the topics of our course here, are out of the scope of private international law, while others against such aspect. I mean, they do believe that not only nationality and domicile are parts of private international law, but also they are the most important topics of private international law. So how could the first category of jurists of international law, I mean the private international law, why do they consider that nationality and domicile are out of the scope of private international law? So this difference in their views would lead to the would lead to to many differences regarding the definition of private international law. Anyway, private international law is defined as it is body of rules, and a definition for any law would start with these three words. I mean, body of rules, which regulates private, personal, and financial relations. So what matters is that the relations are private ones. So there is no sovereignty uh, which is linked with these relations, whether they are personal ones or even financial ones. So these rules regulate private, personal, and financial relations, which contain what? It contains the foreign element. What do we mean by the foreign element here? We mean with the foreign element that there is more than one nationality in the relation, at least two nationalities, but there is no maximum limit. So it's made that the relation contains, for example, 5 or 6 nationalities. However, the minimum limit of the nationalities that are required to say or to claim that there is a matter of private international law is that there must be two nationalities at least. So the relations here contain the foreign element, and they relate one of these topics. First of all, conflict of laws. Okay, so when there are two laws and there is kind of clash between these two laws, which one of them shall apply to the matter which arises between the two persons who enjoy or who enjoy the different nationalities. Like in the previous examples, in the first lecture, we have mentioned that if male who is Egyptian married a female who is, for example, an Italian one, then in this case, which law shall regulate the matter if there is clash between these two persons regarding their marriage or the conditions of this marriage? So the conflict of laws is considered as one of the most important topics in the private international law. The other thing is the international jurisdiction. The international jurisdiction. And actually the difference between conflict of laws and international jurisdiction is that the conflict here is not between laws, it is between the courts. Like we have two courts also, the Egyptian court and the Italian court. Which one of these courts has the jurisdiction to hear the case when there is clash or conflict between the parties to this relation? Well, this is number two. Number three, the foreigner status. Like, what are the rights that are granted to the foreigner when he is in uh, or within the territory of a foreign state? Like when there is an American subject and this American subject dwells or resides on the territory of Egypt, for example. So, what are the rights and the duties that are linked with this person's status when he is in Egypt? So, the foreigner's status is considered also as one of the private international law matters simply because we have two nationalities here, the foreign person and the state that he doesn't belong to. So when there is two nationalities and there is kind of uh, clash that happens between this person and the state where he dwells, then in this case it's matter of private international law, unless it is a criminal matter, because when there is a criminal case or something like that, it's made that the state, like Egypt, adopts the territoriality principle. So if anyone in the state commits a crime, then he would be litigated and prosecuted before the national courts, I mean the Egyptian courts, without any problem. So the criminal courts are out of these matters. I mean here the clash between the foreigner and the state regarding their status, we are talking about private, personal, and financial relations, like civil ones, financial ones, but we don't care about, or the international law and private international law has nothing to do with the criminal matters. Okay, so this is out actually of the scope of private international law. Number four, the nationality. The nationality is considered also as one of the topics, the most important topics, if not the first topic within private international law. The domicile, the difference is that the nationality is jinsiyya, however the domicile is al-mawtin in the Arabic language, and there is difference actually between them. We will highlight this in the coming lectures inshallah. And finally, the sixth matter or subject matter of private international law is enforcing the foreign decisions. It may that you will study this foreign decisions and the course named التنفيذ الجبري or the compulsory execution. You will study the idea of the foreign decisions and how they are implemented uh, within the Palestinian courts. How do the Palestinian courts apply the foreign decisions? Actually, when there is clash regarding these decisions, then there will be a clash between two nationalities, the nationality of the persons who are parties to the foreign decision and the Palestinian jurisdiction. So this is also a matter of private international law. We will talk about this later. So anyway, the definition here, again, the definition, the body of rules that regulates private, personal, and financial relations, which contain foreign element, and this is important in the definition, because if they are nationals, then we're not talking about private international law. And then you have to name the subject matters, which I do believe that they are part of private international law simply because they contain the foreign element. Conflict of laws, number one. International jurisdiction, number two. Number three, the foreign status. And number four, nationality. Five, domicile. And we or the box within private international law, they always discuss the theories of the nationality and domicile in one book or in one part. They always talk about these two subject matters in the same work. And finally, the enforcement of the foreign decisions. So that's all about the definition of private international law. Okay, now we will move to another slide. So subject matters of private international law. Here is a kind of naming for the subject matters of private international law. So the private international law subject matters are conflict of laws, international jurisdiction, foreigners status, nationality, domicile, and enforcement of the foreign decisions. So let's give you like kind of overview regarding each of these subject matters of international or private international law. So I would start with the conflict of laws as the first here topic of private international law. I did not start with the nationality simply because the nationality is the main topic that I will cover during this semester. So I would leave it for next stages after illustrating the number one here, the conflict of laws. So there is consensus among jurists of international law, and I mean here when I mention international law, just for the purposes of this course, the private international law. However, it's not correct to mention it without naming it private. So there is consensus among jurists of international law that conflict of laws, or what do we mean by conflict of laws? Seeking the proper applicable law when there is foreign element in the relation. So let's be back to our example when there is a man who is Egyptian with a woman which who is sorry Italian, and they want to get married, then in this relation we have a foreign element. So if there is problem regarding the conditions of the marriage, then what is the applicable law according to which we have to solve this problem? Is it the Egyptian law or the Italian one? So the conflict of law, as mentioned here, is a main subject matter of private international law. I'm giving here an example, like if a Palestinian bought a movable thing found in France, then a conflict arose between the parties. So the parties to this conflict is the Palestinian person and the French person. So the relation is between Palestinian one with a French person. Then a conflict arose between the parties. The judge here shall seek which law to be applied in this case. Is it the Palestinian or a French one? So the conflict of laws here is a matter of private international law simply because it contains two nationalities, and the problem here is that the judge wants to know which of these laws must be applied to the relation that we have in this example. So that we continue. Also, if an Italian died in Egypt, leaving a certain well, that was brought before the Egyptian court. Now, an Egyptian person, he was like living in Egypt, then he died. After his death, he left uh, a certain well, I mean, like wasiyah, that was brought before the Egyptian court. I mean, the case of the well and how to distribute the well was brought before the Egyptian court. In this case, the judge has to seek which law to be applied, whether in respect of the formal conditions, because there are formal conditions regarding the well, or the objective conditions of the well. Now, one may assume, like I mentioned in the previous lecture, why don't we apply the Egyptian law? I mean, immediately, instead of all of the suffering. Like, why do give a care for the foreign law, and why do we put ourselves in a dilemma, which is seeking the proper law that must apply and that must regulate the problem? Why shouldn't we apply immediately the Egyptian law instead of all of this dilemma? Well, let's imagine this thing. Now, let's imagine that a Palestinian Muslim, for example, is a husband of two wives, simply because the Islamic Sharia, it allows him to do so. And the basic law is, uh, or the basic law considers that the Islamic Sharia is one of the main sources of the law in Palestine. So, and the basic law doesn't have anything that contradicts with the Islamic Sharia. So it is adopted not only by the basic law but also by the Sharia before. So the Palestinian person can marry more than two wives, may reach to four wives. So let's start again. So the Palestinian person, Muslim person, is a husband of two wives. He traveled now to Italy. Okay, then a conflict arose between him and one of these two wives. Like he is married to Samah and Hanan, for example. Now he has problems with Samah, for example. Okay, and they want to get divorced. Now, if the Italian law is to be applied to this problem, simply they are in Italy, and because I don't want to seek the proper law between the Palestinian law and the Italian one, I told myself simply, since the problem is between a Palestinian and the Italian person, however, the problem is here in Italy. Why shall I make like kind of seeking or kind of comparison between the Italian law and the Palestinian one, and which one of these laws shall apply. Why shouldn't I apply immediately the Italian law? Now, focus here. If the Italian law is to be applied, his marriage would be considered a crime, because the Italian law forbids the marriage of more than one wife. يعني احنا بنقول انه بعض الناس بيقولوا ليش احنا ندخل في مسألة انه يعني خلينا نقول ليش نقعد ندور على مسألة القانون واجب التطبيق ونزاع بين قوانين. خلص خلينا نطبق دائما القانون اللي بيكون موجود في محل المشكلة. يعني إذا المشكلة كانت في فلسطين إن شاء الله بيكونوا الأطراف من مليون جنسية، خلينا نطبق القانون الفلسطيني بغض النظر عن جنسياتهم. طب خلينا نشوف هذا المثال بيقول إنه فلسطيني متجوز بتنتين، طلع على إيطاليا وعايش في إيطاليا، الآن صار نزاع بينه وبين واحدة منهم فبده يطلق رسميا واحدة منهم. الآن السؤال لو بده يطلقها وفق تطبيق أحكام القانون الفلسطيني أمام المحاكم الإيطالية، ولا المحكمة الإيطالية تطبق قانونها؟ إذا نمشي ورا كلام اللي بيقولوا نطبق قانون المحكمة الإيطالية، فالمحكمة الإيطالية حتعتبره مجرم وممكن تضعه في السجن لمجرد إنه the marriage of more than one wife constitute a crime. So I have to apply the law that is like that its application is appropriate with the case and the parties of the case and the circumstances of the case. So this is an example which give us the answer. Why don't we apply the Egyptian law instead of all of the suffering? We tell this person who asked this question that the problem is not as easy that he thinks. Simply, the example here gives us an illustration how the problem is not solved in an easy way, like what the person who assumes this question thinks. Okay, one may assume also, why don't we apply the Egyptian instead of all of the suffering? Okay, let's just give you another example here. Let's imagine that an American person, I want to use the pen to annotate because I think it's important while illustrating. Let's us imagine that an American person died in Palestine and he left an inheritance. واحد أمريكي ترك تركة وموجود في فلسطين. His inheritance will be distributed according to the Islamic Sharia, which gives a 2-to-1 shares for the different genders, male and female. Because as you studied before in the inheritance course, when there is boys and girls, the boy takes 2 shares, however the girl takes 1 share. This is according to the Islamic law that is applied in the Palestinian courts regarding the person status or the Muslim person status. Now, for the different genders, they will be given shares in the percentage of 2-to-1, while the law in America gives equal shares for both sexes. So the boy would take the 1 share and the girl will take also 1 share. So they are equal despite the fact that they are 2 genders or 2 different sexes. So if we want to distribute the inheritance according to the Palestinian law, it will lead to like problematic between the inheritor, the heirs or the الورثة يعني, simply because they will demand for equal shares according to the American law. However, the Palestinian courts will give them different distribution for these shares. So the problem is not an easy one to be solved. Also, let's say that an Egyptian divorced his wife and he wanted to marry another woman in Germany, which forbids his divorce. Because some states, it forbids the divorce, like Germany, for example. You are not allowed to divorce your wife. So if you want to marry another one, it will be considered a crime. A crime of what? A crime of marrying more than one woman, simply because the divorce is not existed and is not implemented in the state of Germany. So you are having now two wives. The first, or the first one, which you divorced by just telling some words. However, officially it is not implemented according to the Germany, to the Dutch law. And number two, or the wife number two, the new one. So you have two wives, and this constitutes a crime according to the Dutch law. So the problem is hard to be solved if we want to apply immediately the law of the state where the parties to the relation or the contract dwell, then it would lead to problematics, it would lead to problems. So that's why we are looking for the law that is appropriate to be applied in the relation between the parties to the relation or to the contract when there are a foreign element. So this is about actually the conflict of law. The conflict of law, as I mentioned before, is considered as one of the most important matters of private international law. I don't want to add nothing for this lecture. I just made it 30 minutes, as the administration in the Laza University, they told us that there must be, for the course which is 2 hours course, there must be two recordings. Um, Everyone must be for just 15 minutes. So I tried to combine the two recordings in one record with only 30 minutes instead of making two separated ones. بشكركم كتير على صبركم وعلى حسن استماعكم. إلى أن ألقاكم في محاضرة قادمة إن شاء الله. أترككم في أمان الله وحفظه، والسلام عليكم ورحمة الله وبركاته.